Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. I'm back. I'm not necessarily completely healed. I have had an interesting couple of days. On Friday I had a family member who got ill, and then on Tuesday night I got ill. I suddenly felt like I had a honey badger trying to claw its way out of my abdomen. And so my wife took me to the emergency room and they did a really good job for me. They diagnosed me with diverticulitis and they gave me some pain medicine that was very helpful and worked really well. And then the other thing that they did was they gave me antibiotics, 2 of them, to cover what could be, they thought, a bad infection. But the 2 antibiotics that they gave me, at least one of them, I have a terrible bad reaction to it. On my little finger here, it has swollen up quite nicely to, as you can see, it's turned pretty red there. And that is only a small area that turned red. Both of my feet are bright red and very painful to walk on. So I figured, I could certainly sit here and do some videos because I sure can't go anywhere. Now, I have tried to do this video 3 times, and I've experienced multiple equipment failures, so hopefully we'll get all the way through it this time and not, 15 minutes into it and realize that the audio sounds like click, 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 which is what it did the last time. So let's start by taking a look at the jury instructions from the state of Michigan. Now, I know you may wonder why in the world I would go to Michigan when I'm a Missouri attorney. It's because I've read through their instructions and they're really very good. I think in some ways they're better than the instructions that we give in Missouri. These are the criminal jury instructions, and criminal jury instructions begin with some preliminary instructions. The judge introduces himself and he tells them, look, this is an important part of self-government. Juries exist to protect the public. They protect from prosecutorial overreach, and they also protect the community by putting people who really should be in jail. And then the court ends down here by it says, jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in the trial is entitled to a jurors who will keep an open mind until it's time to decide the case. And then they talk about the selection of a fair and impartial jury. During voir dire, you will hear fair and impartial, I know, 100 times if you go to a place where they have a decent voir dire system. And the trial begins with jury selection. The process is designed to obtain information about all of the jurors or the prospective jurors, I should say. And so they need that to determine whether or not somebody might have a bias or a prejudice. And let me give you an example from from civil court. You have somebody who has been in a car accident and they've suffered a serious back injury in this car accident. So you're getting ready to try that case and you want to look for people who've had car accidents and who have, or maybe who have been sued after a car accident that they didn't think was their fault, but they still had to go appear in court. You want to identify those people because it is a good chance that those people may have a bias against people who sue other people. Similarly, you want to ask about people who have been sued for bad debts, because irrespective of whether you are being sued for a bad debt or whether you are being sued because you hit somebody with your car, being sued is a very unpleasant experience and it's very expensive. And so for that reason, they are going to go into all of that. And the judge will tell them, look, if you don't hear or understand a question, speak up and say so. If you do understand it, you need to answer it truthfully and completely. And that is, I think, probably the most important part of that particular instruction. And then he talks about challenges. And challenges there are 2 kinds. One of them is a challenge for cause. The other is a peremptory challenge. Now, in Missouri, these challenges don't happen until after a fairly large group of people have been selected as potential jurors. In other words, after you've qualified maybe 30 people to be jurors. And then you go through and you sit down with the judge and you say, well, I think juror 42 needs to be removed because they weren't honest when we asked about lawsuits. They didn't mention that they were sued in 1986 for bad debts. So we think that they hid that, and we think that's a problem. We think they should be removed. That's a challenge for cause, meaning that there is a reason above and beyond just not liking the way that juror looks to pull them off the jury. And then there's a challenge for peremptory. A peremptory challenge is basically, I just don't like the way that juror looks, or I don't like the way they answered questions. Even though someone can say, let me give you a good example of why you do a peremptory challenge. Does anyone here have anybody who is a family member or a friend who is on the police department? Yeah, I got one. So would that affect your ability to be a juror? Well, look, my buddy Tom, he's been on the police force for 23 years. He's been shot at, spit on, bled on, puked on, all of that stuff. And he has a really nasty, dirty job, and he does it well. But no, it wouldn't affect the way I look at criminals, And of course, in an answer like that, you would already have given away the idea that you think the guy's a criminal because he's been arrested by the police. So in that situation, if you challenge that juror for cause, the prosecutor's immediately going to say, hey, no, he said he could be fair. And it's about a 50-50. It could go either way as to whether or not the judge would strike him for cause. But if he didn't strike him for cause, you would want to remove him with a peremptory challenge. Now, the key to peremptory challenges is a Batson challenge, and that happens when you're trying somebody of a distinct racial or ethnic minority. For example, if you were in Michigan and you were trying a case involving a Muslim man and you struck all of the people that looked like they might be Muslim off of a criminal jury, you would be violating their civil rights as well as the defendant's civil rights. And Batson, which is a Supreme Court case, says you can't do that unless you have a legitimate race-neutral explanation for it. Mrs. Jones over here, she wasn't paying attention during voir dire. She was nodding off, and I think, there's a good chance she wouldn't be a good juror. That's a legitimate race-neutral explanation. But you can't have the same race-neutral explanation for all the people you take off. So what it does is it levels the playing field for somebody who might be worried about the prosecutor impaneling a jury of only one kind or only one race. So that's why that works. Now, after challenges, they go to the oath for voir dire. And basically it says if you have oaths, if you have a religious conviction that prevents you from taking an oath, you can say that you affirm, that you solemnly affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case. That's the oath. So after they take that oath, that's when voir dire begins. I try very hard not to be like all those other YouTubers who open up every video by asking you to subscribe before you've even seen the content. But now that you've gone a few minutes into the content, if you find this interesting and helpful, please subscribe. I'd consider it a personal favor. The judge will introduce the judges, and the judge, the parties, the counsel, and the witnesses, and all of the court staff. So there are lots of people in a courtroom during a trial. There are bailiffs, there are clerks, there are secretaries who run in with messages. There are all kind of court reporter. There's a court reporter there taking down everything. And all those people are introduced. The lawyer for the state's introduced. The lawyer for the defendant is introduced. The defendant is introduced. The witnesses who are going to be called in the case are introduced. And then they ask, anybody know any of these people? I've had people in a jury that stood up and say, yeah, I know Mr. DeWitt. Well, how do you know Mr. DeWitt? Well, he writes a lot of articles for respiratory therapists. Oh, okay. So that guy was taken out of the jury because it was pretty apparent that, he liked what I had written. So you have to be really diligent about getting people who know any of the witnesses. And the reason you have to be careful about getting people who might have unfavorable or even favorable views of witnesses is that sometimes people who don't tell you what they know, but they know that, John Doe on the jury, or I'm sorry, John Doe on the state's witness list, that guy is nothing but a liar. When they get into the jury room, that's what they're going to share. Hey, look, I know that guy. He is a complete loser, and it poisons the jury. And so you have to be careful about getting all of that information, and that's what the process is all about. And so they ask, does anyone in the jury box or waiting to be chosen know the defendant or any of the lawyers or witnesses? And then they will pursue that. They tell them what the length of the trial is going to be, and they ask if there's any hardships to let the court know. They talk about health questions. Do you have a medical problem that might make you unable to sit for 3 or 4 hours at a time? Does anyone have a sight or hearing problem? And those are important things too. Now, on that score, I have a good friend, Tom, who's a friend of mine in Florida, and he's 72 years old, and he is just one of those Southern gentlemen who is honest to a fault. When he was asked in Birmingham, Alabama to serve on a jury, they asked this particular question about health-related issues. He stood up and he said, I don't have any real big health-related issues. He said, but I'm 72 years old. He said, and I drink coffee in the morning. And you know what? At some point in time, that coffee's got to come out. And I don't want to embarrass myself by raising my hand to say that I've got to go to the bathroom. So if it's okay, if that happens, I'll just stand and walk out. And of course, the judge said, no, that's not okay, and you can be dismissed from the jury pool, which was probably a good result for him. So that's how the healthcare questions work. Now, the next thing that happens in a criminal case is they read the information. And essentially, what that is it's the elements of the case. So, for example, in an armed robbery case, here are the elements that have to be proved. The defendant is charged with armed robbery. So first, they have to prove that the defendant used force or violence or assaulted or put in fear, the state's complaining witness. So, Mr. Jones who owns the Quickie Mart. Second, the defendant did so while he or she was in the course of committing a larceny. A larceny is the taking and movement of someone else's property or money with the intent to take it away from that person permanently. In the course of committing a larceny includes acts that occur in an attempt to commit the larceny, during the commission of the larceny, or in flight or attempted flight after the commission of the larceny in an attempt to retain possession of the property or money. Third, that Mr. Jones, the state's complaining witness, was present when the defendant was in the course of committing the larceny, and then that while in the course of committing the larceny, the defendant either possessed a weapon, displayed a weapon, possessed some object could be used as a weapon to put somebody in fear. And fifth, the defendant inflicted an aggravated assault or serious injury to the other person while in the course of committing the larceny. So those are the elements of, in Michigan anyway, of an armed robbery. And so after those elements are read, the court will then say the defendant is pled not guilty, and you should understand what I've read is not evidence. The information is read in every criminal trial so the defendant and jury can hear the charges. You must not think it's evidence or that it means that they must be guilty because they've been charged. Now, I know what a lot of you are thinking right now. You're thinking, well, there is some truth to that, and he must be guilty if he's charged because everybody who's guilty is charged. But that is not a good logical way to think about it. And unfortunately, there are people who do think, well, even if he didn't do this, he probably did something else. We ought to convict him. That kind of thinking is very dangerous because it's not rational. It's not rational to think that just because somebody has been accused by the state of doing something that they actually did it. The jury, and our history, I should say, is full of cases where juries got it wrong and they convicted someone on that basis. Now, why does the court tell these jurors that's the case? Why do they say you have to maintain this presumption of innocence? So, one of the purposes of reading these instructions is so that jurors will hold each other accountable to those instructions as they go through the case of the criminal trial. Now, after the information is read, they talk about the presumption of innocence. A person accused of a crime is presumed to be innocent. The crime is made up of parts called elements, and of course, we just went through those. The prosecutor has to prove each element of the crime beyond a reasonable doubt. Now, a lot of times, the reason that they start in a criminal trial with these gory photographs of somebody who's been shot or stabbed or dismembered or something like that is to get the emotional rush at the very beginning. This is a terrible crime. Somebody did it, so it must have been him. The defendant is not required to prove their innocence. The prosecutor has to prove each element of the crime beyond a reasonable doubt. And then it tells them that a reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or a possible doubt, but a doubt that's based on reason and common sense. One of the things that they say in Missouri is that you have to be firmly convinced of the facts of the case, that the facts support the evidence, and that a reasonable doubt is a doubt that is developed on the basis of the evidence, which is essentially what Michigan says here. And then they go into procedural instructions. They give them their juror oath. And the juror oath is this: each of you do solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and they will render your verdict only on the evidence introduced and in accordance with the instructions of the court, so help you God. So that is the juror's oath after the jury is picked. But up to this point, up to the point where we're just talking about the elements of the case and what a reasonable doubt is, up to that point, we haven't picked a jury. Now what happens is you have 40 or 50 people who are qualified, and the judge will say, okay, what about juror number one? The defense says, yeah, they're okay. Prosecutor says, yeah, they're okay. So juror number one gets set. What about juror number two? Judge, I'm going to exercise my peremptory strike on behalf of the state because I don't feel like he was honest when he was talking about his prior experience with the law. So the judge will strike number two as a peremptory. He's out. You can be excused. Go on your way. Number three comes up, and the prosecutor says, I'm fine with him. And the defense says, I want to exercise a peremptory strike. Now, there are a lot of suggestions in the media about how to pick a jury. The bottom line is you're looking for somebody who can be fair. You really, if you're the defendant, you really don't want them to be fair to the state. And if you're the state, you really don't want them to be fair to the defendant. But the process is designed to elicit questions and answers that yield somebody who can do both, be fair to both parties. It's not perfect, and I've had jurors go against me when I thought they shouldn't, but it's the best system that we have under the circumstances. So, they take the juror oath, they get a written copy of the instructions. So, you can refer to them during trial. Since no one can predict the course of the trial, these instructions may change. Legal principles. Now I'll explain some legal principles you'll need to know and the procedure we're going to follow in the trial. So the elements of the charge, we've already been through that twice now. They give those, and they say the presumption of innocence again. Trial procedure. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he or she may make an opening statement after the prosecutor makes hers. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his or her evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witness. After the prosecutor has presented all of his or her evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his or her innocence or produce any evidence. If the defense does call any witness, the prosecutor has the right to cross-examine them. After all the evidence has been presented and the prosecutor and defendant's lawyers make their closing arguments, like the opening statements, these are not evidence. They're only meant to help you understand the evidence and the way each side sees the case. You must base your verdict on the evidence only. And then they go on to the function of the court and the jury. They tell them, look, my job as the judge is to decide legal questions. Your job as the jury is to judge factual questions. You decide what the facts are. And any decision you make in this case is final as to the facts. And of course, the judge judges the law. And then the court gives information to them about judging credibility and the weight of the evidence. So these are very interesting. You can find these online if you want to study them. But basically they tell them, look, does the witness seem to have a good memory? Does the witness look and act? How do they look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Now, I would submit to you that if South Carolina had a jury instruction like this, that Becky Hill wouldn't have needed to say it to the jurors. But that's essentially what she said. In general, does the witness have a special reason to tell the truth or any special reason to lie? For example, the state's going to knock 5 years off of their sentence, something like that. Considering only evidence, what evidence is. When it's time for you to decide the case, you're only allowed to decide the evidence that was admitted in the case. Evidence includes only sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions are not evidence, they're only questions. Only the answers are evidence. Court's questioning not a reflection of opinion. If I ask some questions myself, the judge meaning, these questions are not meant to reflect my opinion of the evidence. I will ask questions only when my reason to do so would be about things that may not have been fully explored or explained. So he's trying to help clarify things for the jury. Questions by jurors are allowed. During the trial, you can ask, if you think of an important question that would help you understand the facts, you're allowed to ask such questions. You should wait until after the witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, pass it to the court staff. They'll give it to me. Don't show your question to other jurors. If your question's not asked, it is because I determined under the law that the question should not be asked. Don't speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case should you speculate about what the answer might have been. I'll give you a good example of this. You're in a criminal case, and they finished with this witness who is talking about what the defendant did, and they look kind of skeevy, and nobody has said anything about this guy's criminal record. You write down, does this witness have a criminal record? And you send that to the judge. The judge is going to look at that and he's going to say, it's irrelevant, I'm not asking that question. So you notify the court of an inability to see or hear witnesses or evidence. During the trial, there's going to be objections. My ruling for or against one side are not meant to reflect opinions about the facts of the case, because that happens. One of the things that happened recently in trials is one of the lawyers was always saying, thank you, Your Honor, after he got a ruling from the bench, making it appear that the judge was on his side. Wink, wink, That's not how we do things. We don't do things that way for a reason, and he should have known better. But they'll get rebuked for that. And then you disregard out-of-presence hearings. So sometimes they get together at the bench, they hash something out. They usually turn on the white noise generator so you can't see can't hear what they're saying. And you're not supposed to pay any attention to those interruptions. Now, during the Darrell Brooks trial, they sent those jurors out every 15 seconds, it seemed like, and they were told not to pay any attention to those interruptions. But I can guarantee you that to some extent, they did pay attention to the number of times that Darrell couldn't behave. You're not supposed to discuss the case until you get to deliberations, and you're not supposed to be interested in or caution about publicity in cases of public interest when recessing. During the trial, you don't read media and you don't give interviews or anything like that. So to be fair to both sides, you have to follow that instruction. And these are the kind of jury instructions that are given during the opening phase of a trial so that all of these things can be told to the jury so they're ready to listen to the facts and listen to the evidence and render a decision. And I'm going to stop right there because I've gone over all of the things that really are of importance in terms of getting the jury prepped to hear the evidence. After they hear the evidence, then they have to get the final jury instructions, which include the verdict directors. I'll talk about that on part 2. So thanks again for watching. If you have any questions or comments, please leave them in the comments down below or email me at the address above. If you have the opportunity today, do something kind for someone, and then come back here and catch me tomorrow, where we'll do this all over again. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.